the children are suffering at the hands of plaintiff not allowing defendant his proper parenting time, not wanting to co-parent, and it's not fair to the children, especially when they have that desire to have that time with the defendant.
And just because a 16-year-old decides that she doesn't want to have her cell phone taken away for violations of the rules at dad's house, or because mom's encouraging her not to go, she's being allowed to be engaged sexually. Mom has now put her on to the pill. Dad doesn't agree with that, and so he imposes some structure.
Court can have you incarcerated until such time as that happens. So I want you to be aware of that, that as we proceed, that is a possible you to go to jail until such time as you turn the child over. So just making sure that mom does attempt to facilitate that parenting time. I know she doesn't want to go to jail. Court doesn't want to have her go to jail, but I will tell you, when parents have not attempted to facilitate that, I have put parents in jail for that. So just so you know. Court will note the appearance of Mr. Carroll on behalf of the plaintiff, Mr. Scott on behalf of defendant. This matter is before the court on the defendant's motion to show cause in this particular matter. I guess I'll ask you, Mr. Carroll, are you opposing the motion in this matter? If so, looks like we're going to have an evidentiary hearing.
Well, Judge, what I found is they didn't disclose at all that we had recently been before the court to request a therapist for Kelsey.
Okay.
And at that time, Kelsey had already been not going to dad's house. And we entered an order that I think it was the order you entered on May 8th, Judge, that at that point we indicated if she was going to parenting time, she'd be allowed to take a cell phone. So I just thought it was rather disingenuous that they didn't bring that up. And then he's been filing individual complaints with the front of the court. So they actually set a show cause date, Judge, on July 8th anyway. But I think in the end, I thought the goal of the court and everybody was to have this young lady work with a therapist. She's 16, and we brought a motion for a therapist because she was having problems with dad's house.
Okay.
I would hope wait for the therapist to get some time under their belt with Kelsey to determine what's the best direction to take.
Okay.
But Your
Mr.
Honor,
Carroll, we did refer the matter for a therapist. Why would it not be appropriate to let the therapist deal with the matter, and then we can have a hearing at that point?
Mr. Carroll or Mr. Scott?
Mr. Carroll, it's Mr. Scott's motion.
Yeah, it's my, yeah. Oh, go ahead, Sean, if you want to.
No, I think exactly, Judge. I agree. I think we should have the therapist work with Kelsey. She's 16 to find out what's going on.
Okay. Mr. Scott, why wouldn't that be appropriate?
Yeah, thank you, Your Honor. First of all, really the facts of this really aren't that disputed. There was a motion for a therapist because the young lady was not liking the rules basically at dad's house. Dad said, you know, I don't want a therapist. She doesn't need a therapist. She's just not liking what I have. You've ordered the therapist and the therapist is gone, but nobody's moved to modify this court's order at all. The parenting time needs to continue. It's a court order. The defendant has week on, week off parenting time. He's appeared each and every week to pick up the child for parenting time. That order has not been modified, nor has Mr. Carroll or his client even attempted to suggest that that order be modified. The fact that the child's getting therapy, that's great, whatever it is that they need to do, but he doesn't lose his parenting time because the 16-year-old is having therapy.
I understand.
Yeah, and so really, we have 43 days now, Your Honor. We have fees that are being incurred because this order is just being ignored. And just because a 16-year-old decides that she doesn't want to have her cell phone taken away for violations of the rules at dad's house, or because mom's encouraging her not to go, we attached to the complaint and request for an order to show cause, where mom is in fact talking to this child about, hey, do I have to go? Do I have to go? Do I have to go? And mom's saying, we're working on it. We got stuff filed before the judge, but nobody has sought to change the parenting time. So it's really, I think I attached the Porter case for this court's review, which says, you know, if we don't have the ability to enforce these parenting time orders when there isn't any significant reason why this parenting time shouldn't be being had, other than a 16-year-old saying, I don't want to go because dad's rules in essence are basically something that I don't agree with. I mean, Your Honor, she's having apparently she's 16 years old and she's being allowed to be engaged sexually. Her mom has now put her on to the pill. She's also being allowed at 16 years old to go to MSU parties from down there. Dad doesn't agree with that, and so he imposes some structure which is really good for these for a 16-year-old child. Not to have mom buck this. He's put rules on the phone, Your Honor, and mom says, well, I'm just going to get her a phone then so she doesn't have to listen to it. And then she's writing to her. You can see in the text message of the motion that Mr. Kennedy provided that mom's saying, hide the phone.
Okay, well, what we're going to do is the court does want the therapy to proceed in this matter, and that'll help the court discern what the problem is in the case. I am going to the matter with the referee that was set for it relates to child support, so that can proceed. What the court will do is we want to get from the therapist probably sometime, and maybe we can get a report from the therapist by August 1 in this matter, and then we could schedule the matter in before sometime in August before school starts, and hopefully get the matter resolved. At that point, I would state in this matter, court will have plaintiff appear in person in this matter for that evidentiary hearing. And I will let the plaintiff know, ma'am, you have a responsibility as a parent to make sure that the child, again, that the parenting time does go as ordered in this matter. And the court can, not saying I will, but the court can have you incarcerated until such time as that happens. So I want you to be aware of that, that as we proceed, that is a possible remedy. It's for you to go to jail until such time as you turn the child over. So,
well, we asked also in the motion, Your Honor, that pursuant to the Casberg versus Casberg decision, just basically what the court just said, that the mom be given an affirmative duty to ensure that the parenting time happens. If she was not wanting to go to school, Your Honor, she would take some disciplinary measures to make sure that she's going to school, taking away privileges or something like that. That's what a parent does. This child isn't being beat. This child isn't being, this child is not, I didn't interrupt you, Mr. Carroll. This child is not being hurt or anything else like that. She has a disagreement with her dad about the rules that dad's imposing, which,
okay. Well,
we have.
Okay, hopefully the, again, that admonition to the plaintiff will assist her in proceeding and following the orders. And if not, then we'll have to address that at the evidentiary hearing.
And Judge, just so the court's aware too, and I know counsel may have misspoke, Mr. did not show up on at least one of the occasions. On another occasion, they were picking her up from school and she's 16 and doesn't go with stepmom. So I understand, and I have a good sense of what the court's saying. I want to hear from the therapist as well, but we adamantly disagree with a lot of dad's views in this particular thing. I think he just decides he wants to blame mom for things that are going on at his house.
Well, I understand, and we'll address that at the evidentiary hearing if we have to, but at this point, just making sure that mom does attempt to facilitate that parenting time. And I know she doesn't want to go to jail. Court doesn't want to have her go to jail, but I will tell you, when parents have not attempted to facilitate that, I have put parents in jail for that. So just so you know.
No, we don't need her to go to jail.
We just need that.
We don't need her to go to jail, but Your Honor, I know that's a relief that's available. We just want to have parenting time to occur. And if it's going to be that contemptuous, then that seems to be a last resort. But there's an affirmative duty that she can encourage and provide some disciplinary measures that she's going to have to adhere to if she doesn't go.
Okay, well, I think we've addressed that. I'm not going to rehash it.
Okay.
That will be what the court orders, and you're free to go. Have a good day.
She indicated to me that she is at a church camp. She had a prior engagement to be a counselor and wouldn't be able to appear today.
Arbogast versus Travis Arbogast.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Frost on behalf of defendant. This matter is before the court on the defendant's motion for modification of custody, parenting time, and support.
As the court just noted, we are before the court today on our motion to modify physical custody, parenting time, and child support. The parties to this file were divorced before this honorable court on November 7th of 2022, at which time a custody and parenting time order was put in place. Pursuant to that order, the parties were awarded joint legal, and plaintiff was awarded sole physical, with defendant receiving parenting time as the parties agreed. In sum, the defendant was awarded a minimum of 73 overnights per year. From entry of the order, and again, November of 2022 until June of 2023, the parties remained residing together in the marital home, where defendant had full access to any and all parenting time, and so did plaintiff. But since the plaintiff left the marital home in June of last year, the defendant has not been afforded his parenting time. Plaintiff has come forth disputing this motion, stating that there is a default schedule in place that if the party cannot agree, he's still awarded parenting time. But what plaintiff fails to acknowledge is that the default schedule still isn't being followed. Plaintiff's primary argument in her response is that it's the children's choice, or the oldest child is taking the youngest child to defendant's house, or, they have chaotic schedules. And to a degree that the schedules, which I'll touch on, that's fine. But plaintiff is essentially using the children as scapegoats to detract away from the fact that she isn't providing defendant his parenting time. Defendant does pick up the minor children, not every time, but he does pick them up primarily for his parenting time. And he has no issues with them being involved in sports and other activities, but he's not being provided the information from plaintiff or the kids, but primarily plaintiff, because that's her duty to co-parent with defendant, as to what these schedules entail, and that he's going to miss his parenting time, or that he could show up and attend these activities. He's not being provided that. There have been—
Ms. Frost, under 722.30, he has a right to request all that information from the school, so he can request it himself. He doesn't have to rely upon the plaintiff.
And I don't disagree, Your Honor, but I think it circles back to the issue of the fact that plaintiff simply doesn't want to co-parent with him, which is a factor.
I'm saying regardless, he has a right to get that information. He can do it. So the court's not persuaded because she's not providing it, that, again, there's some issue that he is not able to have that information. He can acquire it in a different way. And again, that doesn't address the issue before the court. So let's address the motion in this matter.
Understood, Your Honor. Again, our primary focus in the motion is the fact that, we need a modification of that custody and the parenting time in order to be in the best interest of the minor children. The current arrangement in the stipulated order that parenting time is as agreed upon is not working. The children have expressed a desire to spend more time with the defendant, their father, and it's not occurring. And I believe that a interview of the children under the best interest factors would delineate the desire to have more time with him. There has been a change in circumstances since entry of the order. There has been, the normal life changes that Shade v. Wright allows this court to look at to determine if the current parenting time schedule is working or not. The kids are aging. They've moved out of the marital home where they still resided for 7 months after entry of the order. And these issues didn't arise until they moved out of the marital home. Pursuant to Vodvarka, the Vodvarka court, there is that proper cause or change in circumstances that would allow this court to conduct a review of the physical custody and parenting time. The current order, and frankly, plaintiff's behavior at her lack of co-parenting in general, and not allowing the full parenting time to be utilized, is having an impact, and is going to have a long-lasting impact on the children if it's not corrected. Pursuant to MCL 722.27a subsection 8, parenting time shall be granted in specific terms if requested by either party at any time. There is not a specific parenting time provision for these parties. It's as agreed upon. There is a default, but the default still is not being followed. These parties would the parties and the children would benefit from having a set schedule that this court would enforce. And I think that it's also important to note again that this was a stipulated order reached by the parties. They used the same attorney to help facilitate that. There was never a best interest analysis conducted, nor was there an analysis of the established custodial environment. And under MCL 722.23, the court is required to evaluate those factors contained within the statute. And then pursuant to Phillips v. Jordan, which is cited at 241 Mich. App 17, the trial courts can't blindly accept the stipulation of the parents, but must independently determine what's in the best interest of the minor child. And that's what needs to happen now. The stipulated order is not working. The children are suffering at the hands of plaintiff not allowing defendant his proper parenting time, not wanting to co-parent, and it's not fair to the children, especially when they have that desire to have that time with the defendant.
Okay.
Yep.
Ms. Frost, I'm looking at the judgment of divorce in this matter, and you're saying that there's not specific parenting time, but it provides for alternating holidays. It provides for alternating weekends, summer vacation as well. So I guess I'm at a loss as to what it doesn't provide when it states it's right in the judgment.
Again, Your Honor, the initial parenting time is as agreed upon. And if the parties can't agree, then it falls back to that default schedule. And the default schedule is it's not working. It's not being provided. And the plaintiff has looked at it as, we agree with parenting time, but simply doesn't want to agree with any parenting time and doesn't want to follow the default schedule.
Well, then what you need to do is you need to file a motion to show cause as opposed to a modification. Okay, Ms. McNiff, what's your response?
Your Honor, my response is similar to the court's. I think counsel significantly misunderstands the parenting time schedule. There is a specific parenting time schedule. All Mr. Arbogast has to do is show up and pick up the children, which he says he has done. If he doesn't want them to go to church at 9 o'clock on Sundays during his parenting time, he needs to tell them that and keep them with him. This absolutely is this motion is completely devoid of any indication that there's been either an ordinary life change or a significant change that would allow this court to re-examine parenting time or custody. As the court indicated, this might be a parenting time violation, but there's no specifics even for that. We would need dates. We would need to know how my client withheld the children from their father, if that in fact is true. We're asking for costs because this motion is completely inappropriate and devoid of any actual factual information that would permit the court to make a determination regarding a change in parenting time or custody.
Okay, thank you. Well, in this matter, no, I don't need anything else, Ms. Frost. In this matter, the court does note that, again, the defendant in the motion does have many generalized and conclusory allegations in this particular matter. The court will note that the answer, the plaintiff has addressed many of those allegations in the answer. The court does not find that defendant has set forth proper cause or change in circumstances sufficient to meet the Vodvarka threshold for an evidentiary hearing on custody, so the court will deny that. The court will refer the matter to the referee for a hearing on child support, as that had been addressed in the motion as well. In this matter, the court will reserve on cost and attorney fees. In this particular case, I guess I'll ask Ms. McNiff that you would prepare that order, submit under a 7-day notice of entry.
I will, Your Honor. Your Honor, you previously sent this matter for child support review.
Okay, then we don't need to do that then.
And so are you also denying the request for a modification of parenting time as well as?
Yes, I am at this time. I don't believe that there's sufficient allegations to raise the level to get an evidentiary hearing, so I'm denying that.
Thank you, Your Honor.
Thank you. You're free to go. Have a good day.
Brooke Edwards versus Gregory Edwards. Attorney Kevin Sackrider is here on behalf of the Public Defender's Office.
This matter is before the court on the plaintiff's motion to show cause for violation of the personal protective order. And I don't recall, I'm looking at the file, had we already done the arraignment in this matter or what? Do you know?
I do not, Your Honor.
Okay. Mr. Edwards, I don't recall doing that. Did we do a arraignment previously? If you can look that up.
Not, let me double check. I don't believe so.
This is the first time I've appeared.
Oh, this is your first time, sir?
Yes.
Okay. Well, if it's your first time, we have not done the arraignment. I'll go through that with you. In this particular matter, on the motion to show cause, the petitioner is claiming that you violated the personal protective order in this matter. And she's alleged in this matter that you were outside her home on Tuesday, June 4, 2024, that then on June 7, 2024, that you'd been stalking her by driving by her house several times. At some point that it says she says you had told her that where she was and who she was with, etc. You have a right to, again, contest the charges in this matter. You have a right to attorney. Attorney has been appointed to represent you with Mr. Sackrider. You have the right to remain silent, not have your silence used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to confront witnesses. You have the right to call witnesses. If you cannot get those witnesses to appear, and that you can ask that the court would compel those witnesses to appear on your behalf. Mr. Sackrider, I take it in this matter that it's your client's intent to plead not guilty in this matter. Is that correct?
That's my understanding, Your Honor.
Okay. And so the matter was set. Mr. Sackrider, are you ready to proceed on the violation hearing today, or did you need additional time to do that?
I would ask for statutory adjournment to meet with my client, file an appearance, and subpoena any witnesses.
Okay. Ms. Edwards, you understand what they're asking for?
Yes, Your Honor.
Okay. Well, he has a right to, again, just being appointed, he has a right to, again, the court does, because we had not done the arraignment previously, he has a right to that additional time to prepare the case. So the court will grant the request for an adjournment in this matter. We will be in touch with you, and Mr. Sackrider and Ms. Edwards will be in touch with you as well to see an alternate date that we would be able to come in and hear the matter. So you're free to go now, and we'll be in touch with you and set up another date. Okay?
All right, thank you.
Okay, thank you.
Thank you, Your Honor.
Marley Isaacson versus Benjamin Isaacson.
Court will note the appearance of Mr. Umloff on behalf of plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion for specific parenting time and modification of child support. In this matter, take it from the motion, Ms. Thomas, is you're seeking basically alternating holidays and spring break. I know there were a lot of things that you addressed as it relates to the child support, which we can address when we recalculate that.
Right. Well, Judge, the big thing is, even without that, even if that's not the real big thing, is that the judgment of divorce says that Mr. Isaacson will have weekends, and Ms. Isaacson, now Denton, will have weekdays. So now Ms. Denton is not allowing weekends, and even Mr. Umloff's, when he wrote, we got that answer on Friday afternoon. It shows that their last 2 week schedule, they did have that schedule for the last 2 weeks because she wouldn't let them have them. We have to have specificity, what day, what time, so that we can do it. So our understanding of weekend is after school or daycare on Friday until Monday morning when daycare starts. That's the weekend. So that's what but we need specificity, because right now they're saying now alternate weekends, and that's not what the order says. That's not what the judgment says. It was just entered in January of this year.
Okay. Why don't we ask Mr. Umloff, what's your position on that?
Our position is, if the court is inclined to grant the motion and grant more specific parenting time, we would request that the defendant have parenting time on a schedule of alternating weekends with alternating holidays that do not include school breaks at this time, because the minor child is only 3 years old and is not in school. we would request that his father, David Isaacson, for the reasons outlined in my response, not be permitted to be in the presence of the minor child. We would further request that plaintiff mother, if the court is going to order alternating weekends, that her weekends with the child coincide with the weekends that she is not working at her new job. As far as child support is concerned, we are perfectly agreeable with recalculating according to the formula. We do acknowledge my client has gotten a new job since the child support order was entered. I would simply request that I noted in my review of the materials my client provided to me that Ms. Thomas had sent a subpoena to her employer. I would request that I be given time to also send subpoenas relating to the defendant's income to his employer.
Okay. Well, of course, looking at the judgment that was entered in this matter, and it states under parenting time, says 80-20, says River should stay with mom weekly and on weekends with dad. And that's the extent of it. I guess if we want to modify that, you'll need to have more specific modification. The court would provide, it doesn't provide for alternating holidays, which is standard. The court will modify it to provide for alternating holidays, as well as spring break. And although the child's 3 and not in school, I mean the school breaks, because at some point the kid is going to be in school, and as a result, they don't want to be back here in 2 years and argue about the same thing. So we'll again modify that to provide for the school breaks as well when the child's in school. What happens is it does state that the child will be with mother weekly. So again, and then weekends with dad, it's pretty clear to the court, although it could be more specific, but the court will order that the child will be with the defendant. I'm sorry, with the
That's correct.
with the plaintiff, as it says, weekly. So the court will order, I think the parties have been, is it correct, Mr. Umloff, the parties have been doing the Friday through Monday morning?
Lately, most recently, they've been doing it for the defendant father on alternating weekends. I outlined the kind of 2-week period in my response.
Okay.
Yeah,
Well,
can I respond to that? May I respond to that just briefly?
you can, but again, if you contradict the judgment, I'm following the judgment, so.
Right. No, but the only reason that the last 2 weeks have been that way is because that's what he was allowed to have. And that's why we need the times. It's important that we have time so we know what time to pick up and what time to drop off, because they're not agreeing on that. That's the real crux of this.
Okay, well, what we'll do is, in this matter, the plaintiff will have, again, the parenting time through the week, and that'll be, when we set it from Monday at 8:00 a.m. through Friday at 6:00 p.m. And then we'll add in the alternating holidays and spring school breaks as well. Court will order that the parties would exchange all current income information, and if they filed 2023 tax returns, they would provide those to the other side within 7 days of today's date. And then we'll leave it up to the attorneys to calculate the amount of support, taking all that into consideration. Anything else, Ms. Thomas?
Nothing, Your Honor. Thank you.
Mr. Umloff?
Yes, a clarification, Your Honor. Will the school break parenting time start when the minor child is in school or immediately? We would, of course, request that it start when he's in school, and I think I stated that in my argument.
Okay. Ms. Thomas, what's your thoughts?
When I set up in our number 9, when I set up the what we believe the parenting schedule should be, I did it based on the family law committee, based upon that's with by the time that they're a certain age. So I would ask that it start now. If it's not going to start now, that we would certainly ask for the number of weeks of summer that would coincide with his age.
Well, the court note, based upon what the parties have had, it looks like joint physical. The court will start the parenting time now. We won't wait until school to do that.
Thank you.
Okay, Ms. Thomas,
Thank you,
I'll ask that you would prepare the order, submit under 7 days.
Will do. Thank you.
Caitlin Smart versus Levi Allen.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This is the front of the court's motion to set aside the referee recommendation, which would allow the parties to opt out of paying support through the court. Mr. Magnuson in his motion again identifies that in fact public assistance is involved, and the referee was not aware of that when he allowed the parties to opt out. Why don't I go to Ms. Smart first? Ms. Smart, what's your response to the motion?
We don't have any assistance through the state. When I did give birth, he did have Medicaid, but that we don't do food stamps. We don't have Medicaid now. Both of us have the child under our work insurance.
Okay, but there was a birth expense and all of that. Is that correct? It's still owed to the state?
So we've never gotten a bill, so I'm not sure, because this all kicked off when he changed his address.
Okay, Mr.
We're still
Magnuson, is
together.
that kind of the position now? Is there still reimbursement to the state at this point?
Yes, Your Honor.
Okay. See, Ms. Smart, there's still amount owed to reimburse the state, so you're not able to opt out until such time as that's concluded, and then you would be able to opt out at that point.
Would we is there a way we could get a bill and just pay that off, or does it have to go through child support?
Well, what we'll do is I'll ask Mr. Magnuson to acquire that information, provide it to the parties. And we have no idea how much it is, but again, if he provides that and you're able to pay that, then the court will allow you to remain opted out in front of the court services. If you can't pay it because of however the amount that's involved or something of that nature, then the court would in fact vacate the opt-out order, and then support would have to be paid through the front of the court until such time as that's paid off, and then you could opt out.
Okay.
Okay. Mr. Allen, you have anything questions or anything to add at this point?
Oh, please unmute.
You're on mute, baby.
Is that better?
Yes.
Okay. No questions really. I had insurance on Lincoln when he was born. She had the Medicaid or whatever she had, and we just never received any sort of billing for his birth.
Okay.
So I've just kind of been waiting in limbo, trying to figure out how I'm supposed to pay it or how much needs to be paid.
But do this, sir, is again, provide that insurance information to Mr. Magnuson so that he has that, and then he will provide the information as it relates to the amount that Medicaid paid, et cetera, and then hopefully you can get it resolved through the exchange of that information.
Okay.
Okay. But the court would, so Mr. Magnuson, if you can, again, coordinate and do all that, but the court would grant the motion to vacate the opt-out, again, assuming that, again, we can find out how much, and if the parties can pay it off and reimburse, then we would not need to vacate the opt-out language.
I'll track down that information, Your Honor, and communicate with the parties. And depending on the amount, it may be something we can work out as well. So.
Okay. Okay. Mr. Magnuson will be in touch with you. And again, Mr. Allen, if you would provide Mr. Magnuson with that insurance information that you had on the child when he was born.
Yeah.
Okay. Do that within 7 days of today's date, sir. Okay.
Yeah. When can I expect to hear from Mr. Magnuson?
I don't know.
Yeah, it's as soon as I can find out the information, I'll get with you guys. So
okay,
it's sort of up in the air right now.
Okay, thank you. You're free to go. Have a good day.
Ashley Rocket versus Sean Wright.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the front of the court's motion to show cause. Court had entered a order for genetic testing back on March 25, 2024. The plaintiff failed to appear for the testing on the April 26, 2024 date. in this matter. Have you had any other additional response from anyone, Mr. Magnuson?
There was a phone call from her last week and I returned it and advised her of the date and time of this hearing. And she indicated that she essentially didn't see the need for genetic testing, and I got the clear impression she was not going to comply. Now, I did believe she would appear today, but obviously she's decided otherwise.
Well, what I'll do, Mr. Magnuson, is I'll let you get an order for a new date for testing.
Okay.
Set that alternate date in the order. Also state that in the event that the plaintiff does not show for that genetic testing, that the court would suspend all public assistance available to her until such time as she does comply with the orders of the court.
Very good, Your Honor. I'll prepare that.
Okay, thank you.
Elizabeth Klein versus Matthew Klein.
Court will note the appearance of Mr. Toth on behalf of the plaintiff, defending appearing in pro per. This matter is before the court on the plaintiff's motion to modify parenting time. Mr. Toth.
Thank you very much, Your Honor. I would first note that I did not receive a reply to our motion from Mr. Klein, so I really have no clue what his position is. But what I can advise the court of, Your Honor, is my client has sole legal and physical custody. For 5 years, she's been employed working from home. Her employer has now mandated that those employees who are in her position within the company are required to work a majority of the time in the office. And there is no office located in Calhoun County or nearby. The location in which she has decided to move is a little over 200 miles from Olivet. It's in Indiana, and the present parenting time schedule provides for 2 occurrences which really are going to be impossible to logistically continue with, and that would be the midweek parenting time and then the beginning of the weekend on Thursday. At the time that the court's judgment was entered, the minor child was of preschool age. He is now 5 years of age and will be beginning his career in the regular school curriculum, which requires 5-day-a-week attendance. He'll be attending a school district near the area in which Ms. Klein relocates. And as a consequence, Your Honor, I think the parenting time schedule in this case, as well as the standard that applies, have both been met. In regard to the standard, it would be the standard identified in the Sands case, because clearly any change in the parenting time schedule as requested by the plaintiff will not alter the established custodial environment. The change will certainly be impacted by the logistics of my client's change in her work status. The parenting time statute clearly identifies those factors which the court must consider. And Your Honor, I would request that in the event that the court scheduled this matter for an evidentiary hearing, that their consideration be given to having that hearing occur prior to the commencement of the school year, which I think everybody would agree would best serve the minor child's interests. Thank you.
Thank you. Mr. Klein, what's your response?
Well, good morning, Your Honor. As a response to this, I was not notified of this until last Tuesday. I did not know anything about being moved or relocating to a different area. I've heard nothing about job, having to relocate for a new job or having to report to work. As Mr. Toast is aware, I'm not currently represented. I am seeking legal counsel, so I would ask that this motion be postponed or set for an evidentiary hearing. I've spoke with a couple attorneys and I'm seeking legal advice, and I would like to have some representation in this matter.
Okay, that's fine, and you're entitled to. And what the court will do is I'm going to refer the matter to the referee for an evidentiary hearing. you'll be able to get in faster with the referee than with the court. They'll refer, and then it'll probably take about a month, I would think, before that hearing scheduled. That'll give you sufficient time to get representation.
I appreciate that.
Okay, thank you. You're free to go. Have a good day.
Thank you, Your Honor.
Your Honor, the state is requesting DNA testing in this case. The state's alleging fraud.
Now, I understand that I'm not the biological father, sir. When that child was born, sir, I was in the hospital present, sir. I signed his birth certificate, sir. He carries my last name. The real biological father was nowhere to be found. But my name is on his birth certificate.
That doesn't matter, sir, because you and the mom or you or whoever did it that in front and not in conformity with the laws of the state of Texas. I can put my name on that birth certificate, but that doesn't make me dad, okay? It doesn't.
So why is it that 5 years later, I just don't understand, why is it 5 years later she wants to say now, you know, if this was the case, why did this happen when he was born? Why does it have to happen 5 years later when I try to put myself on child support to see my son? This is crazy.